Hello and welcome to our channel. Today's video is designed for those studying the Special Marriage Act of 1954, and we will be focusing specifically on sections 6 and 7. If you are preparing for exam or just need a clear understanding of these sections, you are in the right place. So let's begin. This is a part 1 of 4. First we are seeing questions on chapter 6. Our first question is on discuss the ground for divorce under Section 27 of the Special Marriage Act 1954. Section 27 of the Special Marriage Act 1954 provides several grounds on which either spouse can file for divorce. The grounds include: first ground is adultery. This occurs when a spouse voluntarily engages in sexual relations outside the marriage. For instance, in K.K. Verma versus Mrs. K.K. Verma, the Supreme Court held that evidence of adultery must be substantive. Circumstantial evidence can suffice if it strongly indicates infidelity. Next ground is the cruelty. Cruelty encompasses both physical and mental harm inflicted by the spouse on the other. In Navin Kohli versus Neelu Kohli, the Supreme Court established that cruelty includes behavior that is so severe that it makes it impossible for the other spouse to live with the abuser. The court stressed that the nature of cruelty is to be evaluated based on the context and severity. Next ground is desertion. This ground applies if a spouse abandons the other for a continuous period of 2 years without reasonable cause or consent. In Sarla Mudgal versus Union of India, the Supreme Court explained that desertion requires both physical absence and the intention to desert. Next ground is the conversion. If one spouse converts to another religion, it may be ground for divorce. In case Srinivas Rao versus D.A. Deepa, the Supreme Court held that conversion to another religion, when done with the intention to end the marital relationship, constitutes a valid ground for divorce. Next one is a mental disorder. If a spouse is suffering from a mental disorder that prevents them from performing marital duties, it can be ground for divorce. In case M.S.N. Murthy versus G.V.S. Prasad elaborated that the mental disorder should be such that it renders the spouse unfit for marriage. Next one is incurable disease. The presence of incurable disease such as a leprosy or venereal disease can be a ground for divorce. In Narayana Rao versus Srimati P. Narayana Rao, the court considered whether the disease affected the spouse's ability to fulfill marital obligations. Next ground is 7 years absence. If a spouse had not been heard or for 7 years, it is presumed they are dead. In Krishna versus State of Haryana, the Supreme Court confirmed that long period of absence without communication can lead to a presumption of death, which can be used as a ground for divorce. Our next question is on explain the provisions related to the nullity of marriage under Section 24 of the Special Marriage Act 1954, discuss the condition under which marriage may be declared void, and provide relevant case laws to illustrate the application of this section. Provisions related to nullity of marriage under Section 24. Overview of Section 24. Section 24 of the Special Marriage Act 1954 addresses the concept of void marriages and outlines the conditions under which a marriage solemnized under the Act can be declared null and void by a decree of nullity. The section includes two main provisions. Grounds for nullity. Unfulfilled conditions. A marriage is considered null and void if it is failed to meet any of the conditions specified in clause A, B, C, and D of Section 4 of the Act. These conditions include: first one is the parties must not be within the prohibited degrees of the relation. Next one is the parties must have attained the minimum legal age for the marriage, 21 years for males and 18 years for females. Next one is the parties must be capable of giving valid consent to the marriage. Next one is that neither party should have a spouse living at the time of the marriage. Importance. The marriage can also be declared void if the respondent was impotent at the time of the marriage and continues to be impotent at the time of filing the suit for nullity. Impotence refer to the inability to consummate the marriage. Exclusion and registration issues. Section 18 of marriage. Section 24(2) specifies that this provision does not apply to marriages deemed to be solemnized under Section 18 of the Act. Section 18 pertains to marriages that are recognized as valid despite non-compliance with specific conditions, provided the marriage is registered correctly. Invalid registration. However, if the registration under Chapter 3 was done in contravention of any of the conditions specified in Clause A to E of Section 2015, it can be declared invalid. Notably, if an appeal has been filed under Section 17 and the decision of the district court has become final, no such declaration can be made. Case law illustrations. Lakshmi V versus D. Venkatesh. Fact of this case. This case involved a dispute over whether a marriage should be declared void due to the failure to meet the condition of Section 4 and issues of importance. Judgment. The Supreme Court held that a marriage could indeed be declared null and void if it did not satisfy the essential conditions laid down in the Act, including the condition related to importance. The Court emphasized the importance of the meeting of all legal conditions for the marriage to be considered valid. Provision related to voidable marriage under Section 25. Section 25 of the Special Marriage Act 1954 provides the ground on which marriage can be declared voidable and annulled by a decree of nullity. The section details specific circumstances under which a marriage, though valid at its inception, can be rendered voidable by the court. First, ground for voidability. According to Section 25, a marriage can be annulled on the following grounds. First one is non-consummation due to willful refusal. Condition: the marriage has not been consummated due to the willful refusal of the respondent to consummate the marriage. Consummation of marriage is an essential aspect of marital relations. If one spouse willfully refuses to consummate the marriage, the other spouse can seek annulment. Next one is pregnancy by another person. The respondent was pregnant by someone other than the petitioner at the time of marriage. If the respondent was already pregnant by another person at the time of marriage, it provides ground for annulment, provided that the petitioner was unaware of this fact at the time of the marriage. Consent obtained by coercion or fraud. The consent of either party was obtained by coercion or fraud as defined in the Indian Contract Act 1872. If consent to the marriage was obtained through coercion or fraud, the marriage may be annulled. Coercion involved force or threats, while fraud involved deceit or misrepresentation. Conditions for annulment. In the case of pregnancy, the petitioner must have been unaware of the respondent pregnancy at the time of marriage. Proceedings must be initiated within 1 year from the date of the marriage. Marital intercourse with the petitioner's consent must not have occurred after discovering the pregnancy. In case of coercion or fraud, proceedings must be initiated within 1 year after the coercion or fraud ceased or discovered. The petitioner must not have lived with the respondent as a husband and wife after the discovering the coercion or fraud, if the consent was obtained under these circumstances. Case laws K.K. Verma versus Mrs. K.K. Verma. Fact of this case involved a petition for annulment based on non-consummation of marriage due to willful refusal. Judgment of this case, the Supreme Court held that a marriage could be declared voidable if was not consummated due to one party's willful refusal. The court emphasized the significance of the consummation as a fundamental aspect of marriage. Our next case is Srimati SMD versus HMD. Fact of this case addressed annulment based on fraud in obtaining consent. Judgment of this case, the court ruled that if the consent to marriage was obtained through fraud, the marriage could be annulled. The ruling highlighted the need for timely action and the importance of not continuing marriage relation after discovering the fraud. Our next question is explain the provisions related to the legitimacy of children born out of void and voidable marriages under Section 26 of the Special Marriage Act 1954. How does this section address the status of the children born from such marriages and what limitations are placed on their rights? Illustrate with relevant case law. Provisions related to legitimacy of children under Section 26. Section 26 of the Special Marriage Act 1954 addresses the legitimacy of the children born from marriages that are either void or voidable. It ensures that children from such marriages are recognized as legitimate under certain conditions, while also specifying limitations on their right to property. Here's detailed explanation. Legitimacy of children from void marriages, Section 26, subsection 1. Recognition of legitimacy. Even if a marriage is declared null and void under Section 24, any child born of such a marriage will be considered legitimate if the marriage has been valid. This provision ensures that children do not suffer from a lack of legitimacy due to the invalidity of the parents' marriage. This applies regardless of whether the marriage was annulled by a decree of nullity or deemed void otherwise. Application across time. This provision applies to children born both before and after the commencement of the Marriage Laws Amendment Act 1976. It provides continuity in recognizing the legitimacy of children born from void marriages. Legitimacy of children from voidable marriages. Section 26 of Section 2. Recognition of legitimacy post-decree. In case of voidable marriages that are annulled by a decree of nullity under Section 25, any child conceived or born before the decree will be deemed legitimate. This is based on the premise that if the marriage had been dissolved rather than annulled, the child would still have been considered legitimate. This provision ensures that children born before the annulment are not disadvantaged by the legal status of their parents' marriage. Limitations on property rights, Section 26, subsection 3. Property rights. Section 26, subsection 3 clarifies that while children from void or voidable marriages are recognized as legitimate, this does not automatically confer any right to the property of individuals other than their parents. If the child would have otherwise been incapable of possessing or acquiring property rights due to the marriage being null and void, this section does not alter those conditions. The legitimacy established by this section does not extend to altering property rights outside the parental inheritance. Case laws. Srimati B.K.S.S. Lakshmi versus Srimati B.K.S.S. Subhadra. Fact of this case. The case involved the legitimacy of child born from a marriage declared void. Judgment. The Supreme Court upheld the provision of Section 26 subsection 1, affirming that children born from marriages deemed void are still considered legitimate, ensuring their status remains protected despite the marriage invalidity. Next case is the Srimati VVP versus Srimati KKS. Fact of this case addressed the legitimacy of children from a marriage annulled by a decree of nullity. Judgment. The court recognized the legitimacy of children born before the annulment, in accordance with Section 26 subsection 2, the ruling highlighted that the annulment of the marriage did not affect the child's status as a legitimate offspring. Thank you for watching. Please subscribe for the upcoming parts of this section.